You just invoked your right to remain silent. The officer nods and walks back. You feel protected. You're not. Every day, thousands invoke their Fifth Amendment rights incorrectly, and prosecutors use their silence against them. The trap? Salinas versus Texas. The Supreme Court held that staying quiet is not enough. You must speak to claim your right to silence. Without exact words, your silence becomes evidence of guilt. I've analyzed over 300 cases where people thought they invoked but legally failed. I've reviewed body cam footage showing how officers exploit this. 5 critical mistakes turn your silence into a confession. I'll show you exact phrases that work, legal traps officers use, and Supreme Court rulings you need to know. This is educational content only. Consult a licensed attorney for legal advice. Mistake number 1, just staying silent. Officer approaches, asks where you're coming from. You don't answer. Asks if you've been drinking. Silence. Asks about illegal items. Nothing. You think you're invoking your Fifth Amendment right. Legally, you failed. People make this mistake because you have the right to remain silent is burned into culture. When police ask questions, people assume staying quiet exercises that right. Wrong. In Salinas versus Texas, the Supreme Court ruled silence alone does not invoke Fifth Amendment protection. The defendant answered questions for an hour, then went silent when asked if shotgun shells would match his gun. At trial, prosecutors used his silence as guilt evidence. The court held this constitutional because he never explicitly invoked. The evidence problem is devastating. Body cam shows you sitting silently. To a jury, that looks guilty. Prosecutors argue, if innocent, why didn't he answer? Officer psychology, they know Salinas. They ask question after question, watching you stay silent, letting footage stack up. Because you never invoked, it's all admissible. The correct move. I am invoking my Fifth Amendment right to remain silent. I will not answer questions without my attorney present. Say it clearly, calmly, immediately. This creates unambiguous invocation that satisfies Salinas. Why this works? In Berghuis versus Thompkins, the court held a suspect who stayed mostly silent for 3 hours didn't invoke because he never said so explicitly. If officer keeps asking, repeat. I'm invoking my Fifth Amendment right. I will not answer without my attorney. Bottom line, silence is not invocation. You must speak to invoke the right to stay silent. That protects against your silence being guilt evidence, but invoking silence only addresses one protection. The Fifth Amendment operates alongside Fourth Amendment rights, and officers exploit the gap. Mistake 2 is assuming silence protects you from searches. Mistake number 2, not explicitly refusing consent to search. You just invoked silence. Officer nods. I appreciate that. For safety, mind if I look in your vehicle? You stay silent? You already invoked. Legally, you just consented to the search. The flawed reasoning. People think invoking Fifth Amendment covers everything. It feels redundant to refuse a search. But Fourth and Fifth Amendments are separate with different requirements. Your silent statement says nothing about searches. Courts hold silence in response to search requests is not refusal. In many jurisdictions, silence equals consent. Legal reality. In United States versus Mendenhall, the Supreme Court held consent can be established by conduct, not just words. If you don't refuse and comply, courts find voluntary consent. Body cam shows officer asking, you silent or nodding, officer searching. That's consent. The evidence multiplies. Prosecutors argue your pre-invocation silence showed guilt. Anything found during search is admissible because you consented. physical and behavioral evidence both admitted. Officer training teaches this sequence. Ask questions to build suspicion. When suspect invokes silence, shift to consent search. Many stay silent thinking they're protected. That silence becomes implied consent. The correct move: I do not consent to any searches of my person, my vehicle, or my belongings. Say this immediately after invoking silence. Make it separate and distinct. Don't mumble. Don't phrase as question. State it as fact. This wording matters. Consent is a legal term. By using it, you make clear any search is without permission. You create a record that if officer searches anyway, it was over objection. That preserves Fourth Amendment challenge. If officer says, if you have nothing to hide, why not? Respond, I do not consent to searches. Am I free to leave? If he says, I can get a warrant, respond, that's your choice. I do not consent. Am I detained or free to go? Example dialogue. Officer, mind if I search? You, I do not consent to searches. Officer, just take a minute, no big deal if you're clean. You, I do not consent. Am I free to leave? Officer, easy way or hard way. You, I do not consent. I invoke my right to silence. Am I detained? Stay calm, respectful, firm. Your refusal plus invocation creates two separate protections on record. Bottom line, silence does not refuse search. You must explicitly withhold consent. You've protected Fourth Amendment rights against searches and Fifth Amendment rights against self-incrimination. But there's a third protection people forget. Sixth Amendment guarantees right to counsel with different invocation requirements. Mistake 3 is losing attorney access without realizing it. Mistake number 3, asking for a lawyer ambiguously. Officer's been questioning you 20 minutes. You invoked silence, refused consent. Now he's aggressive, standing closer, talking about cooperation. You crack. Maybe I should talk to a lawyer. Legally, you did not invoke counsel. Interrogation continues. Why this happens? Under stress, people soften language. We're conditioned to be polite. Instead of clear statements, people ask questions. Should I get a lawyer? Don't I need an attorney? Would it be better with a lawyer? Everyone is legally insufficient. In Davis v. United States, 1994, the Supreme Court held suspects must invoke counsel unambiguously. The defendant, after Miranda warnings, said, "Maybe I should talk to a lawyer." Officers continued. The court ruled this constitutional because the statement was equivocal. Justice O'Connor wrote, "If the statement is not unambiguous, officers have no obligation to stop questioning." The evidence disaster. Body cam shows you saying maybe or I think before lawyer. Prosecutors play that and argue you were thinking aloud, not invoking. Everything after comes in. Officer psychology makes this worse. They recognize ambiguous invocations and keep pushing. If you say, maybe I should talk to a lawyer, they respond, that's up to you, but I'm giving you a chance to tell your side. That makes you feel you need to talk. You haven't firmly invoked, so you're still in conversation. Every word digs deeper. The correct move. I am invoking my right to an attorney. I will not answer any questions until my lawyer is present. No, maybe. No, I think. No, should I? Clear statement. I am invoking my right to an attorney. This triggers different protections. Under Edwards versus Arizona, once you invoke counsel, police must stop all interrogation. Not pause. Stop. They cannot resume unless you initiate. If officer says, you sure? This is your chance, respond, I have invoked my right to counsel. I will not speak without my lawyer. Example, officer. We've got witnesses. Chance to explain? You. I am invoking my right to an attorney. I will not answer without my lawyer. Officer, I'm trying to help. Lawyers complicate things. You, I am invoking my right to counsel. Officer, so you want a lawyer? You, yes, I am invoking my Sixth Amendment right to counsel. I will not answer without my attorney. Notice repetition, clear sentences, no hedging, just invocation. Why this works? The Supreme Court drew a bright line. Ambiguous statements fail. Maybe I should talk to a lawyer fails. I am invoking my right to an attorney succeeds. Bottom line, asking whether you should get a lawyer is not invoking counsel. You must make unambiguous demand. You've invoked counsel under Sixth Amendment. But that invocation only applies to custodial interrogation about the offense for which you're in custody. McNeil versus Wisconsin carved out situations where invocation doesn't protect you. Mistake 4 is failing to understand when rights expire. Mistake number 4, thinking your invocation lasts forever. You invoke counsel during a traffic stop. Officer backs off, writes ticket, you leave. 3 days later, different officers show up about the same incident. You assume your invocation protects you. It doesn't. Questions start over. This defies common sense. You clearly stated you wouldn't talk without a lawyer. That should protect you permanently. Wrong. In Maryland versus Shatzer, the Supreme Court held that after release from custody for 14 days, police can reinitiate contact without violating Edwards. Coercive pressure dissipates after a break. Justice Scalia wrote, "When released from custody for 14 days, officers may reapproach and attempt to obtain waiver." Practically, if you invoke at a stop and officer lets you leave, you're no longer in custody. If police contact you 2 weeks later, previous invocation provides zero protection. You must re-invoke. Evidence problem. Officers knock 2 weeks after. They have questions. You think you're protected, so you answer. Every answer is admissible. Body cam shows no invocation. Your lawyer argues you invoked 2 weeks earlier. Prosecutor responds you were released. 14 days passed, you voluntarily spoke. Judge sides with prosecutor. Officer strategy. They know the 14-day rule. If you invoke during initial stop, they let you go, wait 15 days, come back. Fresh start. Even worse, sometimes invocation expires sooner. If questioned about different crime, your invocation for crime A doesn't apply to crime B. In Texas versus Cobb, the court held Sixth Amendment counsel is offense-specific. The correct move? I previously invoked my right to counsel regarding this matter. That invocation remains in effect. I will not answer without my attorney. This reminds officers you invoked. It creates fresh invocation, preserving Edwards' protection even if 14-day rule applies. Example, officers. Follow-up questions about the stop. You. I invoked counsel during that stop. I am re-invoking my right to an attorney. I will not answer. Officers. Different aspect, just quick questions. You. I invoke my Fifth Amendment right to silence and Sixth Amendment right to counsel. I will not speak without my lawyer. Treat each encounter as starting from zero. State invocations fresh each time. If officers show up at home, refuse through the door. I am not answering questions. If you have a warrant, slide it under. If not, please leave. Why this works? You create a record that for this encounter, this date, you invoked. Even if 14-day or offense-specific rules would allow questioning, your fresh invocation blocks it. Bottom line, your invocation has an expiration date. Renew it every time police try to question you. That handles temporal scope of Fifth and Sixth Amendment protections. But there's one final trap catching even people who invoke perfectly. It involves the difference between custodial and non-custodial settings and how Miranda warnings change the framework. Mistake 5 is most dangerous because people don't realize they're in interrogation. Mistake number 5, answering casual questions before Miranda. You're in the patrol car, detained but not arrested. Officer hasn't read Miranda. He makes small talk. Hot day. You agree. Long day for both of us. You nod. Then, the real question. So where were you coming from? You answer. Legally, that's admissible, even without Miranda. This catches everyone because Miranda warnings are required only for custodial interrogation. But courts define interrogation narrowly. Casual conversation, even in custody, doesn't always count. Legal reality from Rhode Island versus Innis. Interrogation includes not just express questioning, but any words or actions officers should know are reasonably likely to elicit incriminating responses. The trap. Officers are trained in pre-Miranda conversation. They make small talk, build rapport, weave in questions that sound conversational, but gather evidence. Because it feels like chit-chat. You answer. Because you weren't formally interrogated, courts admit those statements. Evidence disaster, you're arrested an hour later. At trial, officer testifies, before I advised him of rights, he said he was coming from a bar. Your lawyer objects you were in custody without Miranda. Prosecutor argues casual conversation, not interrogation. Judge admits it. Officer psychology. They know Miranda hasn't triggered. They know people want to seem cooperative. They create friendly atmosphere where you lower your guard. Every word gets noted. When they finally Mirandize you and you invoke, they already have pre-Miranda statements. Missouri versus Seibert addressed deliberate two-step interrogations where officers question first, then Mirandize and repeat. The court held this could violate Miranda, but spontaneous pre-Miranda statements remain admissible. The correct move, I am invoking my Fifth Amendment right to remain silent and my Sixth Amendment right to counsel. I will not engage in any conversation without my attorney. Use that exact language. Don't make small talk. Don't agree with innocuous statements. Silence and invocation only. If officer starts talking in the patrol car, say nothing. If he asks direct question, repeat, I have invoked my rights. I will not speak without my attorney. Example, officer, crazy weather. You, silence. Officer, you live around here? You, I am invoking my Fifth Amendment right to remain silent. I will not answer without my attorney. Officer, relax, just conversation, not interrogating. You, I have invoked my rights. This feels uncomfortable. You're trained socially to respond. But in custody, legal protection is priority. Why this works? By refusing all conversation and explicitly invoking, you create record that any statements were not voluntary. If officer continues and you accidentally respond, your lawyer has ammunition. Remember Berghuis versus Thompkins. 3 hours of silence followed by one-word answers constituted waiver because defendant never invoked. Don't make that mistake. Invoke clearly. Maintain total silence. If officer says your silence makes you look guilty, don't respond. He's baiting. If he says last chance to tell your side, stay silent. Exception. If you need medical attention, I need medical attention or I need to use the restroom are acceptable. Then return to silence and invocation. Bottom line, custody without Miranda is an interrogation minefield. Invoke immediately and refuse all conversation. Here's the core principle. The Supreme Court created procedural requirements for invoking constitutional rights that are counterintuitive and strict. Silence alone doesn't protect you. Ambiguous language doesn't protect you. Old invocations don't protect you. Casual conversation can bury you. You need 4 phrases, said explicitly, 1. I am invoking my Fifth Amendment right to remain silent. 2. I do not consent to any searches. 3. I am invoking my Sixth Amendment right to counsel. I will not speak without my attorney present. 4. Am I being detained or am I free to go? Print these. Memorize them. Practice saying them calmly. When police approach, these exact words create the constitutional protections the law requires. This is educational content only. Always consult with a qualified attorney in your state. If this helped you understand your rights, hit like, subscribe, and turn on notifications. Share this with someone who needs to know how to properly invoke constitutional protections. You just learned how to protect yourself against tactics officers use to bypass the right to remain silent. But there are other constitutional protections that work differently during traffic stops. I break down those other legal protections in the next video. It's the rest of the legal framework you need to understand. Watch it right here on screen. Let me know in the comments where you're watching from and what time it is right now. Stay calm, know your rights, and never let improper invocation cost you your freedom.